So I don't know if that had something to do with it, but I mean, I could hardly lift my arm for a few days. But
okay, folks, we are now live streaming. Shannon, you could put us on the record.
Yep, we're good.
Marsh versus Marsh, and we're here on plaintiff's motion for an order to show cause. That would be your client, Ms. O'Brien. I have read what you submitted, but go ahead.
Thank you, Your Honor. As the court's aware, I mean, I wasn't representing Miss Marsh, but there was a hearing in front of you back in December. There was some testimony. Unfortunately, my client was only able to be a part of a portion of that hearing. But anyhow, Your Honor, you ordered that Miss Marsh have parenting time with her minor children, alternating weekends, Wednesdays, and alternating Saturdays, for the friend of the court's reasonable rights of parenting time. And that's simply not happening. I don't know what is going on in Mr. Marsh's home, but you know, the judgment of divorce requires him to foster a relationship between the mother and the children, and to encourage a relationship and not to do things that impair that relationship. And as we stated in our motion, Your Honor, that's not happening. Quite frankly, we feel, based upon the different information that we've gotten and the kids' behavior, that he's actually encouraging them to not go to parenting time and to not have a relationship with their mother. Miss Marsh is currently on the waiting list for the healing place with Dr. Lauder to get into some counseling to see what can be done to help fix this relationship. But in the meantime, Your Honor, she's not being able to exercise her parenting time. Basically, the children are controlling the situation. Mr. Marsh has the children telling Miss Marsh they're not coming to parenting time. They appear to be controlling the ship here, and basically they will go to parenting time for the couple hours on Wednesdays, and that's it. And so, as we stated in the motion, Mr. Marsh failed to provide Miss Marsh with parenting time January 22nd through the 24th, February 5th through the 7th, February 19th through the 21st, March 5th through the 7th, March 10th, and March 19th through the 21st. And then since the filing of this motion, there's been continued denial of parenting time, that being April 1st through the 10th for spring break, with the exception that they did come on that Wednesday, April 7th, for a few hours in the evening, and they spent a few hours on Easter Sunday. And then she was denied parenting time again this last weekend, April 16th through the 18th. So that's the parenting time that she's missed. And again, like I said, the judgment of divorce, as I stated in my motion, requires them to foster, encourage, and support the relationship, and support the other parent in the enforcement of reasonable rules and regulations that we're going to parenting time. But the minor children have the right to the affection and love of both parents, and that neither party will take any action that might estrange the minor children from the other parent or to discredit them. That's exactly, he's doing the exact opposite, Your Honor. And every day this relationship gets broken down worse and worse, and they're getting to the point where, you know, at what point in time are they going to be at the point of no return? And so Miss Marsh is doing everything that she can do. She's reached out to Mr. Marsh to help, to do something to get the kids to come to parenting time. I know that the boyfriend Scott lived there, but she's even offered to have him be gone so he's not there. and nothing. They just won't come. So, and his attitude towards her is, well, I can't make them. So I can't make them.
Thank
Well,
you.
he has to make them. That's his job as the parent. Now, he told you in December that they're well-mannered kids. They do whatever he says. So basically, they'll do everything he says except go to parenting time. I don't buy that. I think that he blames Miss Marsh for breaking up the marriage. He blames Miss Marsh for filing for a divorce, and he is making her pay for what she did, and leaving him by taking the children from her. These are characteristics of a domestic violence relationship. Clearly, Mr. Marsh is maintaining the power and control here. He's using these children as a tool to hurt Miss Marsh for leaving him, and it's just simply not acceptable, Your Honor.
Thank you. Mr. Hotchkiss?
Your Honor, did you get a copy of my answer?
I did.
Okay, good. I didn't hear you reference it at the outset. I've been involved with this family since the divorce began in 2016. I can tell you back then, when the parties were granted joint legal and physical custody, that my client was apprehensive even at that time because the children had a very poor relationship with their mother. There are only 3 left that are under the jurisdiction of this court, but there are also 2 older children. Those 2 older children do not have a relationship with their mother. They don't have contact with her. Quite frankly, unfortunately, plaintiff has not been a nurturing parent and has not developed the kind of relationship with the children that she should have. My client, and you can see by his answer to the motion, has done everything that he can in his power to try to assist in that relationship. He has reached out to the mother and made overtures. Why don't you just ask the girls, hey, to go out to dinner, go shopping, or something like that, which she refuses to do. We had an evidentiary hearing based on my client's motion to change custody back in December. And if the court will recall, there was a great deal of testimony about that fact, that the relationship between the girls and the mother just is almost non-existent. The girls now, they're teenage girls, they are refusing to go to parenting time. My client understands his obligation, not only under the law, but as a father, to try to facilitate a relationship. He believes it to be in the girl's best interest to have a relationship with their mother. Unfortunately, mom is not doing what she needs to do to make that happen. There were some incidents related to her live-in boyfriend that the court heard about back in December, and instead of mom taking appropriate action in offering some sort of resolution to the girls, she defended it and made excuses for it, didn't acknowledge it. And that has put the girls off. They feel like they have not been taken seriously in their concerns. And that's why they go over on the weekday, is because it's not an overnight. There's no chance that they would be there overnight with the boyfriend. You know, Ms. O'Brien talks about, you know, Mr. Marsh not letting them go. Many times when mom shows up to pick the girls, he's not even there. They're just refusing to go on the visits. Now, these are teenage girls. In Mr. Marsh's care, they are doing well. They're thriving. This court some time ago had appointed an LGL in the case. I suspect you may still have that report. And I hate to do this, but if the court is contemplating holding my client in contempt, we would ask for an evidentiary hearing, and I'm going to have the girls explain to you exactly why they don't want to go. You know, this whole, I'll call it a red herring about domestic violence, is nothing but ridiculous. My client has never been involved in domestic violence with Ms. Marsh. And for that to even be raised under these circumstances is just really an act of desperation, because there's no relationship between these girls and their mother, or the relationship is severely damaged. Now, maybe they do need some sort of third-party intervention via a counselor. My client would facilitate that. In his answer, he has indicated to this court that he wants them to have a relationship with their mother. You know, it's completely different than the way that it was explained in the motion for show cause. And you could swear him in today and he would tell you the same thing. I want the girls to have a relationship with her, but he can only do so much to make that happen. And I suppose he could tie him up and push him in the car, yelling and screaming and so forth, but that's a temporary fix that is not going to engender a long-term relationship between the girls and their mother. If that is the goal, which it should be, then there should be a different avenue that should be pursued. You can't make up for 15 years of being an ineffective, non-nurturing parent by force. And that's exactly what they're trying to do here. So if the court needs to hear more testimony or evidence related to this, I think that the only way we can do that is to have the girls testify. Thank you.
So the fact that the girls are willing to go for the midweek because they know they're not going to have to stay overnight, why can't, at least temporarily, till we can get some counseling in place and begin to break down whatever these barriers are and work towards some kind of healing, that we move at least until that can happen to a non-overnight. It sounds like the girls are willing to do that. Mr. Marsh, do you think they would be willing to visit on the weekends as long as they don't have to stay overnight?
Yes, Your Honor, I believe that they would. I've actually been thinking about that the last few days as a resolution to all this, that if we could at least do that, I think they would do it, yes.
And I know that's not what Ms. Marsh wants. She wants them to be there when they're supposed to be there. I get that. But I think the goal ought to be that we would all want them to want to be there rather than to force the issue until some healing can take place. I think as at least a temporary measure, we ought to at least give this a try. I think maybe the more time they spend over there and if Ms. Marsh is working hard to try to rebuild that relationship and rebuild some trust, that in time it might take care of itself. But if they're willing to go, as long as they don't have to spend the night, well, why don't we just try that, at least temporarily? Ms. O'Brien?
No, that's not something I have not been able to discuss that with my client. So before we would agree to that, I would ask to be placed in a breakout room. But Your Honor, one thing, if something like that were to happen, they need counseling. Mr. Hotchkiss talked about the testimony that was provided in December. I got a copy of the transcript, and the only testimony that was provided was a whole lot of hearsay from Mr. Marsh. Mr. Marsh's version of what the children said, that if she would have had an attorney representing her, that hearing would have went much differently. So the GAL, even the GAL said in her recommendation, which I read, said parental alienation. And so I would ask, I think that I agree with you, Judge. Healing has got to take place. There's been so much damage done to this relationship that it's going to take a professional. And that's why we do have Ms. Marsh is on Shannon Lauder's list. But they need counseling. Absolutely. And so I know that's definitely going to be something that's going to have to happen for Ms. Marsh to agree to reduce her parenting time to no overnights. Granted, sometime, even if it's their only daytime, is better than no time, which is what she's getting now. She's getting a couple hours a week. But they need counseling, Your Honor, and I would ask the court to order that so that they've got to participate in counseling.
So you want an opportunity to talk to your client in a breakout room?
If I could, Your Honor, yes. just 5 minutes.
Mr. Hotchkiss, do you want me to create 2 breakout rooms?
Your Honor, I don't know that that's necessary, and I understand where my client's at. Like I said, I've represented him for the last 5
Okay.
years, so I'm good.
Fair enough.
I appreciate it, Your Honor.
Okay, just follow the instructions on the screen and come on back when you're done. Once you're in there, I'm going to take us off the record and we'll wait till you come back.
All right. Thank you, Your Honor.